Hello there, my name is Michael Stokes and I'm Head of Employment and Immigration at Harrison Clark Rickerbys. I'm going to be talking about employment law as it relates to COVID-19 and the end of lockdown, what we hope is going to be the end of lockdown. These are mainly going to be old bits of law. There's no new law in all this apart from the furlough scheme and the end of the furlough scheme. But the old principles that I'm going to talk about are doubly important over the next few months, and that's why we're going to concentrate on those. So the headline topics I want to deal with are the end of the furlough scheme itself. I put a question mark there because we've been here before. The furlough scheme was meant to end last summer. It had another finish date late last year, and now it's carrying on until September this year. So is the furlough scheme actually going to go away? We'll find out fairly soon. It will if lockdown continues in the way it's progressing at the moment. I'm also going to deal with restructuring. That's a very wide term, covers a lot of sins, I think. I'm talking about changes to contracts, possible redundancy situations, selection for redundancy, just general change as a result of COVID-19, lockdown and the return to work. I've mentioned there jab or job. It's a quick way of describing some delicate issues that might arise because of the health concerns of employers, their customers and suppliers, and their employees and colleagues. And then home working. We've been taking part in a massive 12-month experiment in home working, haven't we? And that is going to become part of our normal working life, we think. So how does that affect employment law? How does employment law affect that particular issue? So the furlough scheme, what was it? This time last year we were thinking about it all the time, publishing information about it every other day. The government were publishing new guidance about it, always at inconvenient times over the weekend. In the end it turned out not to be new employment law, it turned out to be a grant application. And all we had to do is learn the rules for how to claim the money to avoid making people redundant because of the effects of the first lockdown and then the subsequent lockdowns. But it was very complicated. It was, in effect, a government-funded or subsidised layoff scheme. A layoff scheme is something that older lawyers like me can remember from the 1980s, and they've been around for a long time in larger workplaces, arrangements where if work ran out for whatever reason, employees could be sent home for less money, but they wouldn't be in danger of losing their jobs. So that's all the furlough scheme was. Furlough was just the new name plucked out of the thesaurus to describe the particular situation that employees found themselves in. The scheme at the moment, as always, 80% of salary up to £2,500 per person per calendar month. That's going to taper off as far as employers are concerned. They're going to pay more. As we approach the end of September, employers are going to pay more and more of a share of their employees' normal wages and benefits. And that was what we expected last year when it was going to end first time around. And so employers are going to come to that pinch point again when they're going to have to decide whether they need to make any changes. If they do decide to make those changes, what sort of things are we talking about? Obvious one is head count, the possibility that an employer may need to reduce the number of employees. What problems does that give us as employment lawyers and in-house lawyers? Pay and benefits. One of the other things that occurred during the longer lockdown period has been changes to pay. So in any situation, any difficult economic situation where an employer is struggling to pay the wages of its workforce because income is down, happened in this case to be because of a pandemic rather than a credit crunch or some wider recession, but wherever they find themselves unable to pay normal wages, they might seek to reduce those wages. And unless the contract allows them to do that, in a way I'll describe in a moment, the employer might have sought an agreement, a variation to the contract to reduce pay, to save people's jobs. And plenty of that happened around this time last year. For some employers, they chose to address it in that particular way. I've mentioned there layoff and short-time working. I've already said that the furlough scheme was a subsidised layoff scheme. It turned into a subsidised short-time working scheme because of flexible furlough. Previously, at the beginning of the scheme, you were off or you were in. You were working, you weren't working in any given week. And now you can be off for parts of a week, but working for other parts. So now it is a government-funded short-time working scheme. Now, there's nothing new about employers, in fact it's a terribly old-fashioned thing, about employers having contractual provisions where they say that in certain circumstances they can send employees home for the whole of a week or part of a week and pay them slightly less as an alternative to redundancy. That's very, very old law and a very old industrial practice. But those terms have largely disappeared from the contracts of employment of most modern employees, and only a few lucky employers found them in their contracts of employment when they came to look at them about a year ago. If they had a layoff term in their contract of employment, they could already send the workforce home without any further agreement because the agreement was in there already. If they didn't have an agreement, that's why everyone had to run around last year getting the written consent of the employees to be sent home for less than their normal pay. If you have a layoff agreement or a short-time working agreement in your contract, you simply trigger that because it's already been agreed, and then you use it for as long as you need it. There are some very complicated rules about when a long-term layoff or short-time working period can turn into a redundancy. We don't need to go into that. But it's definitely worth employers having a look at some of the older contracts in their filing cabinet to see whether there are some useful clauses in there that they might want to introduce now. And last year, again, as people were being sent home for the first time and their agreement was being sought by employers to receive less than their normal pay whilst on furlough, some employers were taking the chance to get the employees to agree to a short-time work or layoff agreement for the future while everyone was in the mood to sign agreements. I think now it'll be more difficult because everyone is thinking of coming back to work, and so there'll be slightly less of a mood for employees to do whatever it takes to keep themselves safe and their employers happy. Employers might get a bit more resistance to the idea of those clauses being inserted. But that is it's going to be a trend. Redundancy. We all know what redundancy is, but it's worth spelling it out. Redundancy can arise where there's a closure of a workplace or where there is a reduced requirement for work of a particular kind in the workplace. So just less work, either completely in a workplace or just in a specific way. So there's less work of a particular kind to do. So when that arises, employers naturally turn their attention to possible redundancies, dismissing people because of that. What do they do then? If we're going to do it in a major way at large employers, and it's going to involve 20 or more employees at any one site, for example, then the employers are going to have to think about collective consultation. I'll come on to that in a moment. Individual consultation is going to be a requirement, whatever numbers are going, and in whatever way it's being done. So individual consultation, that's a definite. And then the selection process itself, that's a difficult area for employment lawyers and employers generally, but there are fairly straightforward ways of getting it right, and I'll try and deal with some of those as we go on. Collective consultation crops up where an employer is proposing to dismiss 20 or more employees within a 90-day period from an establishment. And an establishment is a normal workplace. So my own firm of solicitors might be the Worcester office. If it's a series of factories, it would be the factory in Worcester. That would be the establishment. A lot of case law over the years when big insolvencies happen, because that's when collective consultation usually fails to occur. Last big case was about Woolworths. Lots and lots of branches, dozens and dozens of branches of Woolworths all over the country. Some of them weren't big enough to be dismissing 20 or more people, therefore no duty to consult collectively. But if you've got a big workplace and you're thinking of dismissing 20 or more employees in that 90-day period, you're going to have to consult collectively. Notice I haven't mentioned redundancy in that definition. Most collective consultation situations arise in redundancy, where redundancies are planned, mass redundancies. That's where it appears in the 1992 Act. But really, if you were, for example, going to change contracts of employment by dismissing and re-engaging, come on to that a little later on, then you're going to be dismissing people for reasons that are nothing to do with them as individuals. You might be dismissing 100 people in order to cut their pay by 2%. And that dismissal is going to come under this legislation as well. So if you're proposing to dismiss for that reason to effect changes to a contract, 20 or more people within a 90-day period from an establishment, you've got to deal with collective consultation. Who do you consult with? If you're a business that recognises a trade union for collective bargaining, you've got to consult with the trade union. You have no choice. If there is no recognised trade union, then you have an obligation as the employer to arrange elections of workplace representatives so that those representatives can consult with you. And there's guidance about how you do that. If you're thinking of dismissing 20 or more people, that's a reasonably sizable workplace anyway. If you don't do it, you're in difficulties. I'll come on to the punishments later on. There's no fixed way of arranging an election. You just do it in the most sensible way you can, given the nature of the workplace. Once those employee representatives are elected, then the consultation can start. And the consultation has to be for a minimum period. If it's between 20 and 99 employees, we're talking about a 30-day consultation period before anyone can be given notice of termination. If it's 100 plus, then it's got to be 45 days of consultation before anyone can be given notice of termination of dismissal. What happens if you don't get that right? The protective award, as it's known, that any of the employees or a trade union can obtain through a tribunal claim, either for failing to arrange to have elections, or for not consulting for long enough, or for well enough, sincerely enough, genuinely enough, with the employee representatives. The maximum penalty for that is 90 days gross pay per employee. That's a lot of money if you get it wrong. And the way the tribunals look at compensation is to start at the top and give employers credit for what they have done. If, as an employer, you're in a situation where you should have been collectively consulting and you do nothing, that is, that you don't even arrange elections and you have no workplace representatives, that's a 90-day award, gross pay. So not to be trifled with. I'm going to move on now to redundancy selection. And this comes up, of course, whenever you have to make choices. There'll be some situations where there is no choice to be made. If you are a manufacturing company, for example, and you decide to stop manufacturing a certain type of product, and people are devoted to producing that product all the time, that's their only job, then those people are largely self-selecting for redundancy. If you have one person doing a job and you decide you don't want anyone to do that anymore, could be anything. You just don't want that activity to be carried out at all by anyone, internal or external. That person doing that job is redundant. Their role is redundant. And if you dismiss them by reason of redundancy, no one can say that you have unfairly selected them because they were self-selecting. They were the obvious candidates. Last in, first out, LIFO. Older viewers will remember that. It is no good as a way of selecting people for redundancy in 2021. It wasn't really any good in 1991. It throws up discrimination issues, including age discrimination, because it favours older workers on average, and sex discrimination because, on average, male employees are likely to have longer continuous service because they won't have career breaks for having children. And so automatically, if you use last in, first out, you're going to be favouring men over women and older workers over younger workers, and you're going to be in difficulties. Length of service isn't irrelevant, but it has to be part of a mix of selection criteria. The key thing, first though, is to work out what your pool for selection is. I've talked about situations where a person is self-selecting. There's no alternative, it's got to be them. Where you are deciding to cut down the production of a particular product or a particular service, but you're still going to do it. You just need fewer people to do it. Maybe you're cutting the provision in half. Then you're going to have to select half of your workforce, and you'll need to come up with selection criteria to do that. And the key thing is to work out what sort of employees do you need, what qualities do you want them to have for the future work that they're going to do, and then make your selection criteria produce those people. And you can tell straight away that If you use last in, first out, that doesn't produce anything in terms of quality. What you're going to end up with is not the best workforce. You're going to end up with a slightly more male workforce and a slightly older workforce. And that's probably not what you're looking for necessarily as an employer. You're looking for people to do a better job and to make the business, the organisation more successful in the future. So how do you do that? You come up with selection criteria that are going to produce those people, and you use a blend of objective and subjective measures in order to do that. The key thing is to work out what your pool for selection is, which group of people are vulnerable to redundancy and why. You've got to put a fence around them, and you've got to make sure that your decision about why those particular people are in the within the fence have been selected. Why are they vulnerable and not others? Because employees can complain about how you formed your pools for selection, as well as how they've been scored under the criteria that you come up with. So get your pool for selection right. Does it make sense? And then you apply your selection criteria. That can be anything. It can include attendance, although you have to be careful that you don't accidentally prejudice disabled employees, for example, because their attendance might be less good because of their disability, so watch out for that. Timekeeping, that's a more virtuous measure, objective measure of an old-fashioned kind. Performance, that's a great measure as long as you can measure it objectively. So if you have the manager just marking people from his or her personal experience of each employee, that could be quite subjective. If on the other hand you've got production records, or records of complaints, or records of fees charged, bills issued, commission earned, then those things are good indicators, objective indicators of good performance. So what you're aiming for is a mixture of objective and subjective criteria, and a good mix will look after you in a tribunal claim if it ever comes up. And length of service can be a tie break. You know, if scores are level, then it's been held by the Court of Appeal that length of service is at least good enough to be used as a tie break. You just can't use it as the only criterion. Last point I make on this slide is, and I've had this already since when as furlough's been going on, right at the beginning of the first lockdown period, everyone rushed to the doors, trying not to infect each other, everyone terribly cooperative, and gradually people have filtered back to work, either from home or in the workplace, depending on the type of organisation they're in. A lot of people have been left on furlough all the time, ever since, still on furlough after all these months. And if as an employer you think I'm going to select people for redundancy just by looking at who's still on furlough at the moment, then how have you selected that person for redundancy? Effectively you've selected them by sending them home at the beginning in a rush, not much paperwork around there, and then you have gradually taken back the people you think are probably most used to you, but you won't have kept records of that, why you did it. You won't have necessarily objective criteria explaining why you took those people back and not those ones. So that if you end the whole situation by saying anyone still on furlough, you are selected for redundancy, you've got a very good chance of unfairly dismissing those employees. So don't do that. What you have to do is do what you have to do in any redundancy situation, sort out your pool for selection, sort out your selection criteria, and then deal with consultation, which we'll come on to in a moment. We've dealt with collective consultation if it arises. Individual consultation about redundancy always arises. It's really important that employers don't go into a redundancy process where they've scored people against the criteria they've chosen, or even if they haven't needed to and someone is self-selecting, it's really important to go into a consultation process that is not a done deal as far as the employer is concerned. Because if you do that, it will eventually look like that to a tribunal. It will look like it's a bit of a fix. You've made all the decisions and they're irrevocable, and the employee had no chance once you went through the scores. What you have to do as an employer, and you have to really do it so that it looks as if you're doing it, is to treat the initial decision that someone is at risk of redundancy as a provisional decision. And in documents that someone like me would produce, you're constantly saying to the employees during that consultation process, no final decisions have been taken. This is a provisional selection for redundancy. You are at risk of redundancy. You're giving the employee the chance to come back and say things to argue their case. Have you marked them correctly? Have you remembered that they've got that qualification when you're marking them for skills? You might have forgotten. They might say that there's no reason why they should have a bad score for conduct because you're getting me mixed up with the other Smith. So the employer's got to have a chance to come back, and you've got to build in a process of communication. And that is true even where someone is self-selecting. Your businesses or your organisation's business decisions, commercial decisions about making people redundant should not be vulnerable to challenge in a tribunal, but it's how you do it after that. It's how you put that into effect. That is what's being examined. So build in two-way communication, make the consultation real. Turning now to other post-lockdown issues, the jab or job idea, we're reading about COVID-19 all the time. Vaccination, testing, particular workplaces, either going into people's homes or running a home, a residential home for perhaps vulnerable people. All sorts of situations where people think everyone ought to have a jab. They shouldn't be working here unless they've had a jab. I don't want to work with that person unless they're safe as I am, because I've had my jab. I think the advice to employers in this general situation is do not make a decision a blanket policy. Don't say no one's coming here unless they've had the jab. Blanket policies like that always get you into trouble because there is always someone who's got a pretty compelling reason that might be protected by anti-discrimination law for not wanting to meet your condition. And you're in trouble straight away. They might have health reasons for not having the jab. They might have reasons connected with their family. They might have religious or philosophical reasons that are entirely respectable. It's not all about anti-vaxxers. It might be something much more respectable in society than that. So be careful as an employer before you make big decisions in that way. You're looking after the health and well-being of all the people in the workplace. That might be employees, employers, customers, residents, passers-by, anyone. You're thinking of all of them, and you have to make your health decisions, your health and safety decisions, with all those people in mind. So think about what's necessary for your organisation, what you absolutely need, and how best to achieve it. Always in these situations, especially when employees are coming back from lockdown, they may have been away for quite a long time, either on furlough, shielding in the old days, or working from home more recently. Find out what their issues are. What are their problems? Have they got any? Are they relaxed? Are they worried? Are they worried about themselves, for their families, about their wretched colleagues who, they're always catching colds from? What is their problem? Find out in advance so that you can meet that trouble halfway. It's a good idea in this particular situation. The vaccination and testing regime is changing all the time. It changes every week. There's always information coming out about the effectiveness of vaccines, the effectiveness of the various tests, when they should be triggered. That's always happening. You've got to keep abreast of that if you're an employer. All the more reason not to make rash decisions imposing a policy. It's not a good idea. Just try and be agile. Think about it. Don't make major forever decisions if you can possibly avoid it. Flexible working is going to be the big thing for the next 12 months. We've all been working flexibly in some way or other, most of us. Anyone who's been working at home, anyone who's been coming into the office a little bit, going to the workplace for short periods, doing everything remotely, doing different hours, looking after the kids, doing a bit of work in the evening. We've all been at it. And I think employees some of them like it and have got used to it. Some employers like it a lot and they want to make more of it. They want to make more of it happen. And there won't always be agreement about that. What the last 12 months has shown employers, I think, on average, is that where someone can work at home, it can work. My experience over the years has been that employers have been reluctant to agree to flexible working, home working, because they don't entirely trust their employees to work at home. That's just the truth. That's how employers think about things generally, on average. Lots of good employers out there, but most are a little bit worried about that. But what the last 12 months has shown is that it's entirely possible. It can work. So now employers have got the idea and they potentially want to pick that up. They're much more amenable to that sort of arrangement. And that's a positive. That's a positive, I think, for employees and for employers. Flexibility over hours of work, that's another one. During the more recent lockdowns, when the schools were closed, lots of employers were seeing their employees do their level best to work during working hours when the kids were running around, but people trying to make up the time later on. So employers appreciated that, and good employers have picked up that you can do your work at different times of the day. So that is going to be part of the future. Employers have to be careful though, because if you're going to rely on employees to work at home and you want that to happen, you'll have to take more of an interest, I think, as employers in making sure they've got the facilities to work successfully at home, that they're not prejudiced by their financial circumstances, their personal arrangements at home, so that they can't do it as well as other employees. Have they got the kit? Is it safe for them to sit down at home and do their job? What arrangements have been made for data protection, for example, confidentiality, IT safety? What facilities have the employees got? You can't just, to put it bluntly, dump the responsibility for a safe working space, generally, an ergonomically and generally safe working space, on the employee and say, good luck, do it in your shed at home. If you're going to want employees to work at home, you're going to have to think more about what they need at home. The last year has been an emergency. If it's going to happen in the future, it's not an emergency anymore. There'll be more resistance, I think, from employees to the idea of working at home if it's not convenient for them and they haven't got the kit. Making changes to contracts, general point here, don't go changing contracts without consent. Look at the contract first. I'm thinking of any of the changes we've been talking about: hours, pay, home working, layoff, short time arrangements. Look at what's in the contract first, it's obvious. If you don't see what you want to see as an employer and you want to introduce it, ask nicely. Explain why you need it. Say what the benefit is. Try and talk your employees into agreeing it without there being a punch-up about it. Consult with individuals, find out what their problems are with the changes you're thinking about making. Keep saying this. Find out what the employees' problems are, because then you might be able to address them and they may just agree. If you can't get agreement, and you may need to dismiss and re-engage employees, you've got to then start looking at the numbers. And if you're going to dismiss 20 or more people from an establishment for a reason that's not to do with them personally, it is treated like a redundancy. So if you want to cut their pay, change their hours, and there's 20 of them at the same workplace, and you're doing it within 90 days, they've got to have elected reps or a trade union representative, and there's got to be collective consultation. If you get it wrong, 90 days gross pay per employee. So don't get it wrong. No one knows what's going to happen over the next 12 months or even over the next month. Anything could happen about the next variant along, a new surge, new restrictions. We hope that we're moving gradually towards a slightly looser arrangement. Lockdown will ease. We all like that. The sun's out, the weather's nice. That's terrific. But you have to expect the unexpected. You can't assume that everything is going to go back to how it was before. Home working is a thing. Employees, if you don't give it to them, are going to ask for it much more than they used to, and you have to be ready to think about it sensibly and answer them properly, because they all know they can do it now and that it can work. If we have another massive lockdown because of some new variant, then it would be a shame for employers if they've learnt nothing over the last 12 months. All the things that they had to do in a tearing hurry this time last year, you don't want to have to do all over again in 3 months' time, 6 months' time. So look at what you need. Look at what you needed to agree in haste with your employees last year, and see if you can build in agreement to it for the future while things are going well. Keep a cool head. Don't make any massive decisions unless you have to. Don't make blanket decisions unless you have to. Think about the employees and all the reasons why they may not be thinking in the same way as you. The last point I'm going to make is, when everyone was racing for the door to get away from each other this time last year, everyone was in agreement. The only disagreement was about who was going to go first. It was just, get me out of here quickly as possible. And that's fine. But as people come back over the next few months, more and more, either from home working or from furlough, they've got 100,000 different reasons for not wanting to agree with what the employer wants to do in the future. So the original furlough, the original lockdown, that was the easy bit. When everyone starts coming back to work, or you need them coming back to work, that is the difficult bit, where you're going to deal with hundreds and hundreds of different issues, and you've got to have a good plan for how you're going to address those without having a major falling out with your workforce. So good luck. Thank you.